Unfair contract terms in small business contracts have new penalties. What is your business risk? My name is Kerri Thomas and I'm a solicitor here at Clarke Hemmerling Lawyers. Recently, Parliament have passed new civil penalty provisions for the use of unfair contract terms. These new penalty provisions will throw a wider net to catch small businesses that may not have been covered by the legislation previously. Proposed changes include the introduction of a 5-fold increase in penalties if businesses are found to have unfair contract terms incorporated into their standard form contracts. So what is a standard form contract? As consumers, nearly all of us have purchased a product or service online and clicked a tick box agreeing to terms without too much head scratching. That is a really simple example of a standard form contract. But standard form contracts can also be written contracts between consumers and businesses, commonly used in domestic building, finance and small business goods and service agreements. These standard form contracts are contracts in which the other party must accept the terms on a take it or leave it basis, or typically, the other party is not given the opportunity to negotiate any explicit terms of the contract. The use of standard form contracts are popular in small business, as they can be used to contract large volumes of customers and are cost effective, as they avoid legal and transactional costs associated with individually negotiated contracts. So how do you know if a contract term is unfair? In a nutshell, Australian consumer law guides us that an unfair contract term can be one that A. causes detriment or significant imbalance of rights and obligations of only one of the parties if relied on. B. It is not necessarily necessary to protect the legitimate interests of a party. And C. It indemnifies only one of the parties' liabilities under the contract. A recent Federal Circuit Court case brought by the ACCC held a price varying clause relying on documents that sit outside the contract, disproportionate termination rights and assignment rights only allowed by one party were all unfair contract terms. So what has changed in the new provisions and how is your business at risk? If your business or one of the parties you are contracting with has fewer than 100 employees or an annual turnover of less than 10 million, this will determine whether the legislation applies. Minimum contract values have also been removed. Previously, if the court declared specific terms of a contract unfair, it could only void the unfair terms. But now, if your business does not comply with its obligations when using standard form contracts and is found to be in breach of the new provisions, the court can also impose the new civil penalties as a fine. The upside is it is not all bad for small business, as the new unfair contract terms regime offers a greater detriment and will also protect small businesses when conducting with bigger businesses. To ensure you are not at risk of breaching the new unfair contract terms provisions, contact us here at Clarke Hemmerling and have our experienced commercial lawyers help you review and amend your standard form contract terms.